Thank you for availing yourself once again, Judge Vally.
Thank you, CJ. CJ.
We have this session because the court has ordered that we should have this interview afresh.
Yes.
And thank you for coming back to make yourself available. I see that you have quite a few degrees behind your name. You have a BCom degree, is that right?
Yes, that's correct.
And a BA degree.
Yes, that's correct.
And an MA degree.
Yes, that's correct, CJ.
And an LLM degree.
Correct.
And an LLB degree.
That's correct, CJ.
I think some of these are from WITS, is that right?
Yes, all of them are from WITS except the MA.
Except?
The Masters in Sociology, that's from University of Warwick in the UK.
Yes, yes. No, thank you. And you were admitted as an advocate in 1996, is that right?
That's correct, CJ.
And you started practicing as such immediately after
Immediately.
that? And you practiced as such up to 2012?
Correct, CJ.
And before you were admitted as an advocate, you had worked for Kausa or Sakau, is that right?
Yes, it's now called Sakau. It was called Kausa in my time.
Yes, yes. How long did you work for the trade union?
I worked for them for a year, full time.
Yes.
And I worked with them after that on a part-time, on an on and off basis with them.
Yes, yes. So you were in practice as an advocate for about what, 14, 15 years?
I think it's less than that. 1996
to 2006 would be 10 years.
10 years, 12.
So it can't be less than 14 years.
No, it can't be less than 14.
Yeah.
6. My arithmetic seems to have failed me at this point.
Okay.
Another 6. About 16 years,
Yeah. And then you were appointed as a judge in 2012.
In 2012. I must just say that in that period before, while I was still studying, I was a very active member in an organization called IMSA. For those who worked in labor law would know, I was also on the board of trustees of IMSA at one stage. And I did a lot of mediations and arbitrations in that period, but I was still studying to work for my LLB.
Oh, yes. And was that something you were doing part-time?
As soon as I left the sociology department and I started doing IMSA work much more extensively, and I was doing my LLB. More like the LLB was a part-time, I would think. I don't know. No, the LLB was a full-time course, but I'd already I'd done an LLM and an LLB at the same time.
Oh.
And there was an overlap in the LLM and the LLB. So the LLM came before the LLB.
Yes.
I finished the LLM but did not have an LLB at that stage.
Yes. And then you did the LLB after.
LLB after that.
Yes.
Mm-hmm.
Now, would you like to share with the commissioners what the nature of your practice was when you were practicing as an advocate in terms of what types of cases you were involved in?
Well, to begin with, there was a natural flow into labor law. So I could easily do labor law. And I had a lot of people in labor, people I knew in labor law, who would come to me for assistance, particularly from that union and a few others. But of course, there was only so much they could give me because they were also having their own difficulties. But labor law was my initial start. I then moved quite quickly into constitutional law. So you will see from the very early stage, I was involved in pharmaceuticals, which is a major case, nucleics, affordable medicines. I did quite a lot of that sort of work, and some of that work took some time. I became quite involved in work around medicines regulations and medicine and work involving the healthcare. In fact, just to go one step back, I was also chairman of Essential Services Committee at some point. And then when I came to the bar, after a while, the Minister of Health appointed me to the Pricing Committee, which was a committee that was looking into pricings of medicines. So, and that came as a result of my work in the healthcare work, which is the affordable medicines case, the nucleus case, the pharmaceuticals case. They were all quite big cases, and I did many other cases for them that I can't think of offhand right now. So that was that also took a major part of my work. Then I did some work in defamation law at that time. So that was it. I didn't get too much commercial work to my disadvantage, but yes, that was largely a kind of work I was doing. It's been so long since I've been, it's more than 10 years ago. I did do some unlawful competition work, but that was in arbitrations. So I represented parties as part of a team in an arbitration on unlawful competition, not through the competition law, but unlawful competition as part of DLIT. So,
would that be the
I think that
common
the
law
spectrum,
competition?
yes, common
Yeah.
law competition,
Yeah.
unlawful competition in common law.
Yes. While you were practicing, there were some cases that you did that got reported. Is that correct?
Many of them.
Yes. Do you have an idea about how many were reported cases that you
wouldn't
argued?
know it. That I would have, when I applied for Silk, I would have known. Because that went into my Silk application about all the cases that, and there were many. There were very many in which I was involved. In labor law too, I was involved in some very serious and path-finding cases.
Yes. And then you were appointed to the bench.
Yes, I acted for a term and then I was appointed to the bench.
And you have been on the bench for, is it 9 years now? Finishing
my ninth. I'm 10, if you consider the acting stint, yeah, it will be 10 years, yeah.
Yes. And during your time as a judge of the High Court, you have also written some reportable judgments that have been reported.
Many.
Yeah.
I can give you a number, I think about 50 or 45, I don't know, 40 something, many.
Yes. And you have acted in the Competition Appeal Court.
I did. Correct? That's correct.
And was that from 2016 to 2018? I
would think so. Whatever you read, must be correct.
Was that at a stretch or different times during that period?
No, 1 year. I got called in only at that point. So it was a full year. Then I applied. I didn't get it. And I think I continued acting. And then I applied again and I got it.
Yes.
So if it's the competition, if I started in 2016 and acting, then I've been in that court since 2016.
Yes. Okay. You have not had a chance to act in the control court, is that correct?
That is correct.
Yes. But have you had decisions that you have made as a judge of the High Court that relate to constitutional matters?
It's hard to say specifically constitutional matters work. I've dealt with all the matters I dealt with, or most of the matters I dealt with. Constitutional issues arose in them, and constitutional issues were then dealt with by me. Many of those judgments. There was a law, the Black Eagle was one of them. Silicosis would have possibly be another one because it dealt with a number of constitutional issues, right to healthcare. Quite a few of them, and I can't off the cuff remember which ones were constitutional directly, but many of them had constitutional angles to them.
Have you ever given a judgment where you have declared some piece of legislation unconstitutional?
No, never.
You have not?
Never.
Have you had a chance of giving a judgment where you have had to invoke reading in or reading down?
Or striking off? Or, you mean one of the remedies, constitutional remedies that have? Yeah.
Have you had that
No,
chance?
no, not to read in or read out, but
yes.
I had occasion to interpret certain legislation that might have been, or certain sections that might invoke constitutional values.
Yes.
And so applying section 39(2), for example, if you want
Yes.
to know. Yes, I would have done that.
And if you were appointed as a judge of the Constitutional Court, and the first case you got was one where some litigant applied for direct access, what kind of factors would you take into account in deciding whether direct access should be granted?
It must be exceptional for it to come for direct access. I believe it's necessary for the matter to be sanitized at the earlier courts and at the lower courts, for the lower courts to identify what the real issues are. There must be something very special about it, and it must really be in the interest of justice. In other words, that court must say that whatever wisdom that's to come out of the courts below need not is not necessary at this stage. There must also be some level of urgency to it. I mean, why would you want to come directly if you can get the same justice at the lower court? And if that justice is suitable, then why would you want to even come to the Constitutional Court? No, it's not a court that just should be invoked willy-nilly. It's a court that you must come with matters that have been considered carefully by other judges, that has got some sort of controversy that is worth the attention of a constitutional court before it can come. Now, there's been numerous judgments where the Constitutional Court has said, we can't give you direct access, go to the other courts. There's nothing special about yours. It must be exceptional. If there's no exceptional circumstances, I would not be keen on granting leave to come to that court.
If somebody who had lost in the High Court wanted to come to the Constitutional Court for an appeal directly without going to the Supreme Court
by bypassing the SCA.
What kind of factors would you take?
Again, they must indicate why. What is so special about it that the SCA cannot deal with us appropriately? And we must wait. I mean, we don't know what the High Court or the SCA will say. And if they say something that gives a final answer, then that must be it. You don't have to bring every matter to the Con Court for determination. The Constitutional Court is a court that deals with only certain and special issues that require the attention, that it's going to probably assist in developing the jurisprudence in some way. I mean, there must be as I say, something exceptional. And there has been numerous cases, I can't think of them off the hand, where leave to appeal for direct access was never granted, and rightfully so. There's no reason why you should bypass these courts, and the Constitutional Court is entitled to benefit from the arguments, the wisdom that comes out of the High Court. I mean, High Court and the Supreme Court of Appeals. I wouldn't grant leave to appeal or grant direct access. Leave to appeal directly from the High Court, or just direct access even before you go to the High Court. I wouldn't grant that so easily. There must be something special. And sometimes something special would be it's in the national interest, it might be urgent. And I can understand those sorts of cases, but not just any case for that matter.
Thank you, Judge Vally. Commissioners? Commissioners,
yes,
if anybody has a question. Commissioner Matonsela.
Yes, good afternoon. Thank you, Chief Justice, and good afternoon, Justice Vally. I'm here. Somewhere.
His hand is also rising.
Forget about him. Eh?
He says, I must forget about you. But you exist, don't worry. I recognize your existence. Thank you. Commissioner Madonsela?
You have written a judgment in Capitec,
Yes.
and the SCA dealt with it recently.
Yes.
And
it was Justice Unterhalter who overturned it. Yes.
I was just about to say that.
Yes, let's talk about it. Yes. Oh, well, let's go straight to it. Yes.
Yes, yeah,
No, let's...
how do you feel about that? And do you think that I asked this question because I've asked him as well same question around the same topic. I know that case because I'm following it.
Sorry,
I
that
know
case was?
I know that case is now serving before the Constitutional Court, or is
It's going to go to the Constitutional Court. Yeah.
leave to
It's been
appeal.
never applied for leave to appeal.
Leave has been
Yes.
sought and papers are still going to be filed. So between you and Judge Unterhalter, somebody's gonna get a hiding in the Constitutional Court. But that is not the issue. The issue is, do you think that our current state of the law on contractual interpretation is adequate to cover and regulate commerce between individuals? I'm talking in particular about the Indumeni principles and all the principles that
The Indumeni case.
Indumeni and the Auckland Park case, from one of which you had the occasion to consider, and the judgment in Baedieka regarding public policy.
Oh, the Bideka case, yes.
Yes. So,
And Pridwan is the other one. They came
Pridwan-
out on the same day.
They came on the same day, yeah. Saying this more or less the same thing. But I'm saying, are those principles, in your view, sufficient enough to regulate commerce between individuals, or do we need some form of refinement of those principles and a more accurate guidance from the Constitutional Court on that jurisprudence? Or do you think it is quite settled?
I'm going to try not to give too long an answer, because I can give a very lengthy answer and we can have a seminar on this. And I wish we do.
Please go for the shorter answer.
Thank you. When it comes to the shorter answer, as far as I'm concerned, my judgment is firmly located in the transformational constitutionalism project. Whether theirs is, I leave it to the readers to decide. And it will come before the Constitutional Court, and that issue is going to be arising. It will be one of the most important issues there is. Has the law developed on this issue? It is developing. And one of the issues is there is this conflict, this tension that's taking place between the SCA and the Constitutional Court. And it's been referred to openly in the Bideka judgment and to an extent in Pridwan. In Bideka, Froneman J makes a very strong point. He says that the SCA, some of its comments, are pejorative when they refer to the CC judgments. He also says that the SCA did not interpret one of the CC's judgments, and it's a leading CC judgment called Parkesan, correctly. And over the years, people followed the SCA's interpretation of Parkesan, not Parkesan's own words. And he said, let Parkesan speak for itself, but not let. So in Bideka, he's quite strong about it. In Bideka, even the majority judgment, which kind of came to the same conclusion.
Which was written by Justice Leon.
The one by Justice Theron. Sorry. Even that judgment took note of some very disparaging comments that have come out from the SCA. So there has been this tension that's gone on for a long time. The problem really lies in the fact that the SCA itself has been grappling over the years with this difficulty. It's a difficulty I capture quite extensively in my Atlantis judgment. Now, I went and I did the research on my own in Atlantis. And I said, I personally adopt a specific view of of contractual law. I don't believe that our law of contract is as fixed as it was, say, 30, 40, 50 years ago. And I believe some of the inroads that were being made, or that was attempted in some of the early cases, in I think it was Bank of something versus Ornelas, Bank of Lisbon. Yeah, Bank of Lisbon versus Ornelas, where the one judge, Jansen J.A., argues for opening up the law of contract, and he's then shut down, and he said, no, you're the minority of one. And then it moves on. But eventually, the SCA then accepts that we're going to move away from this. That's a contract. That's what you sign. You're bound by it. Tough luck for you, whether it works in your favor or not. Or good luck for you, it works in your favor, and tough luck for you if it doesn't. But for the need for certainty in commerce, you must be bound by it. They didn't follow that principle when it came to Sesven versus Bucas. They said, no, public policy. Bucas signs a contract and he says, I'm an intelligent person, I'm an orthopedic surgeon, I'm handing over my salary every month. They say, ooh, that turns you into a slave. We can't allow this contract to stand. And then they started, and from then onwards, we started saying public policy is the rubric around which we will decide whether a contract is valid or not. And then we applied it later on in other commercial disputes, like, for example, restraints of trade. So contract law is undergoing change. But one of the things that happens is Parkhazen comes up and it says, we need to relook at the situation. We need to introduce concepts like reasonableness and fairness and others. And we need to see how we can bring justice between the parties. It's nothing new. By the time Parkhazen came out, there were cases in England already, and particularly cases in Canada. In Canada, I mean, the Basin versus Hernew judgment is an excellent judgment, but they use the concept good faith. So I apply all of those things. And one of the things that have come out against me in the Unterhalter judgment and the others are wrong. They say, they said I didn't apply Biedeke. Biedeke wasn't out, because the Biedeke I had to apply was the one of Davis J. Secondly, they say I rely on good faith. And good faith is not a self-standing principle. Well, that may be so. I'm willing to listen on that and say we can move away from it. But what the Constitutional Court did say is that public policy will still remain the basis upon which we will determine whether the contract is to be abided by, applied, whether a clause in that contract should be utilized, enforced, should be enforced. But they said that, and they said it up front. What they do in Biedeke is say, look, we're also waving a white flag to you, Supreme Court of Appeals. We don't need this. It's not in the interest of the judiciary, in the interest of law, that the two of us seem to have this open spat. They don't go down the road that they say.
I thought you said you'd give us a shorter answer.
Thank you so much. And they then tried to synthesize the two systems. But I still believe that my judgment in Capitec is correct. And if you look at the facts in Capitec and the way they interpret those facts, you'd sometimes think we're not talking of the same case. What happened in Capitec, for me, was a serious injustice, just like what happened in Afrox. When a person walks out of a hospital, going in there for a simple operation, coming out with one leg amputated and told, sorry, the indemnity clause covers the hospital, you can get no remedy. And that is that Afrox was decided after Parkhazen. I still feel it was an unfair judgment. I still feel it was an unjust judgment. That's my views. I'm a judge like they are. I put my views up front. They don't agree with me, that's fine.
Except that my recollection is that Afrox was decided in the SCA.
Yes, no, it was in the SCA. And they just said, that's it. And that's one of the judgments that refused to follow Parkhazen.
I'm so scared to ask you another question. I have no
Yes, if you can.
Let's just say, look, we disagree about these points. I understand some groups at the bar have had a discussion of my Capitec judgment But they didn't invite me to come and talk. I was going to give an
no,
Atlantis testimony.
let's stop there. Was there a hand this side earlier on?
There was, and I've given up.
You are covered.
that
Oh,
I've covered.
okay,
There
all
was
right. Okay, thank you.
There was a hand
Thank
here.
you. Oh,
Maybe I can take it,
okay, then it will be Commissioner Notjetsi after you. Okay.
Thank you, ACJ. Good afternoon, Justice.
Good afternoon, Commissioner.
I'm going to ask you a very
Ndawe.
common.
Yes.
Yes. I'm going to ask you a very common question. But unfortunately, this is one of the questions that is not going to go away anytime soon until gender parity is realized in judiciary. In one of your answers on the questionnaire, you indicated that you constantly advocated for transformation within the advocate profession and participated in numerous activities. Can you share with the Commission as to what are those activities that you participated in? And while you are responding on that, can you also mention one or two of the women advocates that you mentored while you were still an advocate?
Okay, look, fortunately for me, there are some members in this forum who know what I did from the early period. But what I did is, I mean, something I just continued doing from 1976 onwards. I fought very hard in the advocate's profession for change. I was always I never stood behind. I was always in the forefront of the fights. I always put my name forward in those battles. On mentoring women, if you look at some of the judgments, some of the cases I appeared in, I only had women juniors. I can name them. I think Sina Yakub was one of them. Commissioner Pillay was another one of them. Leah Gabashi might have been one of them. I've had as many women juniors as I could. But I also want to say this. There are some excellent women advocates out there. And it's not a situation of, they say this about women and blacks, as if we're sitting there, we are lesser skilled, and we're waiting for somebody to mentor us. Really what the problem is, give them work. Brief them. They'll do it, honestly. They're not someone who's lesser able than than men, or black people are not lesser able than white people. It's a question of opportunity. And that's where we had our fights, and we haven't succeeded because we're still having those fights. So this thing will continue for so long. But let me tell you one other thing that I've never mentioned, and I was reminded of recently. On the gender issue, if you go back to 1983, we were the first union, Kawusa is the only union that managed to win the maternity battle. We won 4 months 45% wage, and 55% came from unemployment, and 4 months without loss of service. We were the first and only union that managed to get that, and we were constantly fought for that in our union. Our union was led by a woman, and we were very sensitive of that. But that doesn't mean I'm going to bury everything under the carpet. There was a lot of patriarchal practices even within the union. Our men are not necessarily good people when it comes to this question. We must face that fact. So yes, it's a struggle. I've done as much as I could. I could maybe do more. Sometimes you get distracted. Sometimes the battles are around race. Sometimes the battles are around class. But it's an intersectionality between all of those three that one gets involved in. And yes, it's a long way for us to go still. I wish I could have done more.
Yeah, it is a long way indeed, Judge. Thank you so much for your answer. Thank you, ACJ.
Thank you. Then Commissioner Notjetsi.
Thank you, Chief Justice. My question is very short. It's just, I'll make a statement. I just wonder if you agree with it.
I concur.
If you, yes, if you concur. Factors such as unnecessary postponements of cases.
Can you just repeat that?
Factors such as
unnecessary
postponement of cases. deciding matters on pure technicalities, long delayed delivery of judgments, temperament of a judge who presides in a case, are issues that should first never be accepted in a constitutional court setup. Two, they constitute a threat to the independence of the judiciary, because if you go to a judge, delays, does not deliver judgment, you start to panic, and that leads to a temptation to confront those judges, the judges. Do you agree with that statement?
I agree that undue delays, unnecessary postponements, and attempts to allow and or to take technical points in order to avoid having to deal with the real issues are seriously problematic. Most important of all, they undermine the rule of law. That's the more important point. People lose confidence in the rule of law, and that's not what we want. Our constitution makes it quite clear that the rule of law is supreme. So yes, I wouldn't. I believe that those factors are very important, and we must be absolutely conscious of them at all times.
Yes.
We must remember that there are litigants who need justice.
My
And
last question.
even if they don't get justice, they need an answer.
Yes.
Sometimes the answers are not just, like has happened in my view. This is my personal view in Afro.
Okay.
They need an answer.
Okay. My last question. Have you ever been, at any stage, been either accused of or consider yourself guilty of being a judge that was not tolerant to those who appear before you? Your temper. Have you ever been accused of those things, that you are a judge that easily lose it when conducting proceeding? Or are you aware of those things? And if you are, how have you sorted out if it did happen? That's my last question.
Okay. There was a comment, it was raised last time by one of the commissioners. There was a comment in the GCB comments. It was one that has been refuted by other advocates but was never put before this body. There was a comment that was rude to senior counsel, but I was never given details about it. And to date, I've never been given details about it. I've said that at times, I don't know if I come across rude, but particularly with certain types of senior counsel, I tell you honestly, when you sit there, they sometimes talk down at you. They really don't respect you. I don't know why, but some of them do. You have to sometimes put a firm hand on your court. And if you don't, situations can get out of control, not only for you, but for the other side and for everybody else, So you have to at times do so. So being firm is not necessarily being rude. I haven't got any complaints, but I can't say I was never firm.
Thank you, Judge Vally. Commissioner Mpofu.
Thank you very much, TCJ. Good evening.
Good evening, Commissioner Mpofu.
Yes, thank you. Yes, I think we are both tempted to call each other by first names. Yeah. So we'll resist that temptation. I just have one question, TCJ. And it is it's related to this issue about judges and counsel, but from a transformation point of view. You and I have been in that battle zone for such a long time.
Together, yes.
Yeah, you come from the days of Black Advocates Forum,
yes,
before it was even AFT.
Yes.
Now, and I know how passionate you are about this question of briefing patterns. What has been your experience sitting on the other side of the fence, as it were, with watching all the big commercial cases being run by particularly white advocates? And if the former CJ is to be believed, in the Constitutional Court, the situation is the same or worse. of the kinds of counsel who appear before them. Do you think there's something that the judiciary can do using its muscle to complement the long fight that you know around briefing patterns?
You know, as a judge, I certainly can't do what I was doing as an advocate. And so I presume that's going to be applicable to all judges. I accept it's applicable to all judges. We can only nudge them and say, but why have you been doing this situation? A good example is competition law. I did not even do one competition law case in my life. Not one. I'm now regarded as a very senior judge in that court. I am taken very seriously in that court. Ask anybody who appears in the competition appeal court, they'll tell you that.
I am that person and I agree.
And that is to show, I mean, there are so, in the competition field, with the exception of the Competition Commission, parties are not very amenable to bringing, you know, counsel from black, from counsel that are black or counsel that are women. Juniors, yes, they bring them in as juniors, but we've had that fight as advocates. You would second junior, third junior, we don't pay for the third junior. We've tried all those things out over the years. What we're talking since early 2000s, 96. So yes, there is a serious problem and it continues. And it continues in the big firms. And you also find this problem. Some of those firms have at the higher levels changed in color and even maybe in gender, but not necessarily the practices. Now, it's not nice to say those things, but those are some of the observations I have seen. How can a judge help in that? I don't know. What we can do, you know, and I hate this because it's always a case of can we train them? Can we bring them in? Can we give them advice? It's as if they just need training. They don't just need training, they need work. If you give someone work, that's training. He'll train on the job. You know how anxious I was when I first did labor law. I one stage read every single case there was on dismissals for operational requirements. When one of my seniors, whose name was Advocate Moirane, came to my chambers, we were doing new clicks. He said, what is all these files? And I said, no, it's for operational requirements, you know, he said. He says, what do you need them for? I said, no, just, you know, I had idle hands, so let me cover a specific area of law and see if I can have my skills ready in that area of law. You can't keep training somebody until you give them the work. Give them the work and let him apply that knowledge. Get him work hard on it. He'll not necessarily or she'll not necessarily be able to charge for all the hours they do, but get them the work and you will see. That's when the training takes place. That's when someone is being enhanced and advanced.
Thank you, Tisha.
Thank you, Commissioner Mpofu. Deputy President Betzer.
Thank you, Acting Chief Justice. Good evening, Justice.
Good evening.
I've got just one question to you. Of the judgments that were reviewed by the GCB
Yes.
and taken on appeal to the SCA, about 45% of your judgments were overturned by the SCA. Would you wish to respond to that?
45.
Or would you
Well,
just be dismissive of
No,
what
I won't
happened
be
at the
dismissive.
SA and say that
no,
you still
I
believe
won't.
you were right and the SA was wrong?
No, I don't think that's right. No. If I were ever to take that attitude, then I need to be hit on the head. That's arrogance. That's lack of humility. And I think there are times when I was wrong. And in the heat of the moment when I made that decision, I missed a point. It does happen. It will happen in my court. It's an extremely busy court. But the more important point is this 45%. Look, I don't know how many of my judgments were taken. I don't know how many of my judgments where leave to appeal was applied for and not given. In other words, the SCA refused leave to appeal. So I don't know which judgments they're talking of. I don't know what that statistic is. I really don't, but I refuse to accept that that is a fair reflection of the quality of my work or even the level of disagreement between me and the SCA. I don't think that figure accurately captures the level of disagreement between myself and the SCA, or the amount of error on my part that the SCA managed to find. Do you know Justice Nugent? A famous one. When he was in the Supreme Court of Appeals, he used to always assume that, we have these cases, we're overturning these people, as if the Supreme Court of Appeals was always right. But when he was starting to be overturned at the CC, at the Constitutional Court, he then said once in a talk to us, he says, the appeal court is not more right, it's more binding. Let me tell you what Justice Haram says. I meet him in there was the House of Lords. All of them came here to this country, and I was lucky enough to visit that place. And I went up to him and I told him that I don't agree with Breed and Come. I was still an advocate, and I said, it's a problem with Breed and Come's analysis. And then he gave a talk, and you know what he said? He said, we've been overturned by the Constitutional Court, but the case they brought to before us was not the case they took to the Constitutional Court. So when you're on the other side, you see things are, and the SCA must also accept that some of the things said to them are not the things that were brought before us, and there was suddenly a change in their case. And so there's difficult, and I am very conscious of that when I sit in 3-bench appeals, and when they start saying things about the judge that sat in the first court, and say, the judge missed this point or missed that point. I'm very conscious that you don't just go about disparaging that judge. I want to know, what did you do or say there? And it happens a lot in the competition appeal court, where they constantly make those comments about the tribunal.
I'm satisfied, Justice
Thank you.
Vally. I think
Thank
in the
you.
interest of time, we must leave it at that.
Thank you.
Thank you.
Thank you.
Thank you, Acting Chief Justice.
Thank you. Judge Vally, you said, if I understood you correctly, there were many reported judgments that you wrote as a judge. I was trying to look at your questionnaire. Did I hear you correctly, or did I misunderstand?
I don't get the question.
I'm saying that I understood you to be saying earlier you have written many reported judgments as a judge.
Where's my
So
CV?
I'm just having a look at your questionnaire. Maybe there is something I
This is
don't
Judge Unterhalter.
understand.
Okay, there's a list of judgments, Judge.
If you go to page 13, as paginated page 13
I
of
don't have it. Is this it?
your but I think it would have been page 8 of the questionnaire.
This is Judge Unterhalter's.
How did he leave it there?
Put that aside.
Where's yours? Where's yours?
Okay.
Is it yours?
Sentence the wrong person, Acting Chief Justice.
Commissioner
There's a list
Singh?
of judgments. Yes.
Commissioner
I would
Singh?
like to ask a question a little later.
Acting Chief Justice, I think it's page 21.
Okay, I'm sorry. Just hang on one sec, Judge Vally. Commissioner Singh, I'm sorry. You were saying something I didn't hear.
Yeah, I would like to ask a question a little later, Acting Chief.
Yes. Okay. No. Thank you.
Thank
Okay.
you.
All right. What page, Judge Vally?
There's a list of judgments.
Yeah, you see there, page
It says-
21. It says reportable judgments 55.
Yes.
Now, reportable is one thing.
And reported
It means you
is
have marked
another.
it reportable because you
Correct.
consider that it should be reported.
Correct.
But reported
This
is
another
something
thing.
different.
That's correct. That's absolutely correct.
When you are saying many, we talk about reportable.
Well,
as
if you
opposed
look
to
at that
reported.
same list, I don't know, I didn't do this. Firstly, this is outdated. It's now about 140 something, 150, 145 or 147. But if you look
You
at
mean-
that,
you
this
mean-
was prepared by my registrar, not me.
Yeah, but
And if you look at citation,
but would that be an excuse, Judge
No,
Vally?
it's not an
Because would he not
excuse.
give it to you to approve first before you
No,
send
no,
it to
no,
us?
no, that wasn't an excuse and that was not an attempt to evade the question.
Yes,
The question is the difference between reportable and reported.
yes,
That's what the question really is.
yes.
And the question really goes to the heart as to whether I misrepresent to this body, whether negligently or deliberately.
We are not there
or the
yet.
number.
We are not there yet. I'm still trying to understand. So I'm saying when you said there are many, were you talking about those that are reportable, or were you talking about those that have been reported?
Many of my judgments were reported. How many exactly, I can't tell you, but numerous. And if you look under citation, they give you this where it's been reported. So if you look at each of the column, it says there case, date, parties, reportable, and then it says citation. And it gives you some of the citations.
Yes.
And then how many of them now, I can't give it to you off the hand. I will obviously have to sit in. But I'll accept whatever you say about how few they are.
No, I only want to make sure what I understood is what you wanted us to understand. So that's the only thing I want.
Yes.
Because I was looking at page 13, paginated page 13, under question 16. It says, the questionnaire there says, list the cases where you have written the judgment, not more than 10, which you regard as being the most significant and why. You are not there yet? Page 13, paginated
Yes.
13.
Is it
Can you see that
paragraph
question?
16?
Yes, yes.
Paragraph 16.
And then you have got
4.
You have got 4
Yes.
cases. Out of those 4, only 2 are reported in what I understand to be the official law reports. And then in question 16.2, the next question says, which of these cases has been reported? And then the answer is all of the above.
Okay.
So I would have thought that if there are many, those that you regard as significant wouldn't be 4, because most of the reported judgments one would think are important, but sometimes I know it's not like that.
Okay, I think
So I just want to make sure that I understood you correctly and what you were telling me is what I understand.
I think ACJ, first point, this is only the one application. There's an application before this. There are 2 posts. There's one post that only some of us have applied for. And that application got 10 judgments that have been annexed to them. It's not here, I don't know why. This is the second application in which you only got four of the judgments. So that in total you would have had 14 judgments before you right now. Secondly, let's deal with the question of all of the above. And there your argument, your concern, Acting Chief Justice, is that the only issue is, only judgments that can really be regarded as reported are those which says 222 all SA or 224 all SA. That's correct. But those judgments, Hermione and Nell, is in the South African law reports as far as I know. And it's an important judgment about contracts and interpretation of contracts. And I also applied the role of good faith there. Then the Transnet IGS consulting was about corruption and about, if I recall, it was about setting aside a tender or something, I can't remember. And that too was reported. Where and when, I don't know. I leave that to my registrar to do all of those things. And she's excellent. I'll have to check out what there is, but I do have many reported judgments. That there is no doubt. I wouldn't be misrepresenting to this body. I have no reason to misrepresent to this body.
Okay, no. I just wanted to make sure I understood you correctly.
Thank you.
It looks like there are no further.
No, as a follow-up,
Yes.
DCJ, Judge Vally,
CJ.
when you come to an interview of this magnitude, one of the things you would expect is that you're going to be asked about reported judgment.
Yes.
And therefore, it can't be an acceptable excuse that we're now told about someone else who prepared, because in your preparation for this interview, you would have refreshed your memory about how many are reported judgments, because it's going to be a bone of contention when we go into deliberations that we're unable to give us how many factually, backed by whatever submission that is required from you to submit before this body, that these are reported judgments. So I'm worried that when you leave here, I don't have a clear answer as to what are the reported judgment, even if it's an estimate, and then we can go and deliberate about that.
Thank you, Commissioner Malema, for that, for giving me an opportunity to clarify this issue. I certainly don't know exactly how many were reported, and I'm sorry I didn't check that out before I came here. I do apologize to this body for not checking that fact out. I have written there reportable, and I've also written there the number of citations. I've given that. I did not count the numbers. I'm so sorry about that. But I can safely say, without fear of contradiction, that the number is well into the tens. It's way above 20, 30, 40. It's in that ranges. There's a lot of reported judgments that I have given. I've listed all of the judgments I've got there. And I have not, and I have no interest in exaggerating. I honestly don't have an interest in exaggerating the amount of reported judgments. There's no value for me to exaggerate something of that nature. And I do apologize to you if it is going to make your deliberations somewhat more difficult because you don't have that answer. I'm sorry for it. Thank you, Mr. Malema.
Just the last question. Did you say there was another application you made, though you made two applications and some of the reported cases are in another one?
No. Yeah, no. There's two applications that this body is considering two vacancies. There are two applications in those two vacancies. The one was done in October 1919 or something, 1919. 2019. I think it was done in 2019. The interviews were set down for March 2020. Then we all know COVID hit. It was extended to October 2020. Then that didn't take place. But then adverts went out in October 2020 for the second vacancy. And then that's this application. Then we know what happened after that interview process, and the court has told us to come back here, which we are. And there's been another advert for two vacancies. And so there's another application as well, a more recent one. What I'm saying to you now, to answer you directly, Acting Chief Justice, is today you should have had two applications before you. There were two. I don't know why you've only got one. Because you're considering two positions, and not all of the candidates have applied for both.
Okay, thank you.
Thank you.
Judge Vally. I think we have come to the end.
Acting Chief Justice.
I'm sorry. Commissioner Singh, I'm sorry. I'm terribly sorry. I forgot about you. Please.
No, thank you, sir.
Yes.
Thank you, sir. Good evening, Judge Vally.
Good evening, Commissioner Singh.
I've come across a news article, which I think it'll only be fair for you to respond to. And if I may read it, it's not very long. The heading is, Judge made a material error in inverted commas, relying on non-existent document in controversial 14 billion rand contract case. and it's a newspaper, City Press. It says at the center of the predicament is Judge Bashir Vally's reliance on a confirmatory affidavit, which he said was deposed by Eskom former group legal head Bartlett Hugh. The affidavit never submitted as part of the court roll because it allegedly never existed. This fact is confirmed in an admission made by Eskom attorney Aslam Musaji when he confronted a text message by Hugh regarding Vally's alleged inclusion of evidence he did not submit. I think it'll only be fair, because this is a public news reporter, Judge Vally, that you be given an opportunity to respond to these allegations.
Thank you, Commissioner Singh. Okay, that's a recent judgment I gave in which Eskom sets aside, asked to set aside what was a contract of 8 billion rand on the grounds that the contract was irregularly obtained. The issue that newspaper article, which I've not read but I know about because it was sent as a questionnaire to my registrar who brought it to my attention. The issue raises on this very minute point, and that is that Eskom board took a decision that they will not procure certain types of fuel oil from intermediaries, because that only adds to the cost. They would rather buy that fuel oil directly from the supplier. In other words, they would go directly to BP or to Cecil, but they would not want to give it to get an intermediary to go and buy it from Cecil, put up a markup and do this. So that's a resolution Eskom board is supposed to have taken. There's a controversy now in the case. Did Eskom board take this resolution or not? It's a very minute part of the case. The case is long. It's been included in my third bundle of cases. In that case, one of the employees, the most senior employee, that is a Mr. Who's the CEO of Eskom? De Ruyter. Mr. De Ruyter puts in a main affidavit. And in that main affidavit, he says there has been this decision taken by the board. He's not able to put up the board resolution. I then criticized that in my judgment, saying that's non-compliance with the Companies Act. He then says why and how they took that resolution. One other gentleman, Mr. Shitangano, was at the board meeting. This particular gentleman, Mr. Heu, was also supposed to have been at the board meeting. They gave me papers of about 2,000 pages that constituted 2,000 pages, and both those gentlemen gave confirmatory affidavits, except Mr. Chitangano went a bit further. He just didn't give a confirmatory affidavit. He went further. He said, and I did this. The other gentleman didn't say all those details, but as far as I know, and I tried to look for those documents, we don't have them anymore. They've been given away. He gave a confirmatory affidavit. But here's the thing, even if I was wrong that there was no confirmatory affidavit, it doesn't change the finding of fact, because that finding of fact was based on numerous other issues. It was based on numerous other evidence. And then lastly, that finding of fact was also one small aspect of the entire case. The case is about how that contract was given to this organization, I think it's called Econ Oil, how it was given to it, contra the principles set out in the Procurement Act and the regulations in the Procurement Act, contra the policies of Eskom. Then came a third aspect of that case. Was there really a contract or not? And there came the question of whether the formalities of whether a contract was entered into were actually complied with, whether they did meet those formalities. So this issue is a really minor issue, and I think it's blown way out of proportion. But I accept your point. It's in a newspaper. It cannot be taken seriously. They have applied for leave to appeal to the SCA. If they get leave to appeal, it will be dealt with there. I'm confident that the judgment won't be overturned, but I could be wrong. And it's important to be confident. It doesn't necessarily mean confidence is the same as being right. I'm confident, but I'll accept that there is a chance that the SCA will find against me and reinstate that contract. I set aside the contract. I said, firstly, there's no contract, but I set aside the whole process that they went about in this, giving this 8 billion rand contract to this company, which it shouldn't have been done in the circumstances it is. That company may deserve that contract, I don't deny that. But the circumstances in which they did it was, I said, wrong. So Commissioner Singh, I can't see you.
No, but he hears you. I'm sure he hears you.
I don't know if that answers your question.
I can hear you, ACJ, if I may just follow up. You see, the thing is...
Sorry, Chief Justice, may I just caution against what is taking place at the moment? If the article was not really put to the candidate beforehand, I think it may very well be unfair to press on this line of questioning. I want directions and counseling from you.
Commissioner Singh, you hear the concern from Commissioner Madonsela that...
yes, ACJ, I hear the concern. It's an article I only came across today because it's a 15th of September article, but I'll leave it at that. I'll make up my own mind about how I interpret what Judge Vally has said. Thank you.
Please go and read the judgment as well, Commissioner Singh. It's unfair for you to make a decision on a newspaper article, Commissioner Singh.
Okay.
I mean, read the judgment.
We are done. Thank you very much, Judge Vally. We have come to the end of the interview.
Thank you so much.
We are sorry that we made you wait.
Thank you, Chief Justice.
We are running late, but you are now excused. Thank you very much.
Thank you, Acting Chief Justice, and I wish you all the best in the rest of your endeavors.